First of all, I would like to express my thanks to Professor Javed Rahman and all his colleagues for extending this kind invitation to me to attend this conference. It is indeed an honor and privilege to be here. Protecting divorced women's rights by the application of principle of Mata, a case study of India, Pakistan and Bangladesh, is the working title of an extended article, and my presentation today is based on this work in progress. Muslim personal law has remained a contested issue, and bringing any change in this area of law in the Muslim world has been to a great extent highly politicized. Post-divorce maintenance or Mata is one such area that has become a subject of heated debate and controversy in India, Pakistan and Bangladesh. The ruling governments and the right-wing political and religious leadership in these countries have always resisted and are often reluctant to engage in any discussion on reforming laws pertaining to women. Now, in this paper, I seek to examine the issue of Mata or post-divorce maintenance in light of the Quranic provisions on maintenance, views of the four Sunni schools of thought, and contemporary Islamic scholars. I argue that by using ijtihad and its accompanying juristic techniques, Mata or post-divorce maintenance can be awarded to the divorced wife in legally pluralistic societies. To achieve this end, the debate on law reform and protecting women's rights needs to be reframed by emphasizing the egalitarian ethics of Islam. I also examine some of the key cases on post-divorce maintenance decided by the courts in India, Pakistan and Bangladesh. By providing a comparative perspective of the various interpretations of the Islamic principle of Mata, I assess how the courts have responded to deal with such controversial issues in the absence of any specific legislation. And by way of conclusion, I argue that there is a need for an inclusive approach. Only then it would be possible to bring a law reform. Now, in Islamic legal discourse, the support in favor of Mata or post-divorce maintenance for divorced wife after the expiry of period of Iddah is based on the Quranic verses 236, 240 and 241 in chapter 2. Verse 236 refers to a suitable gift according to the means of the husband to the wife at the time of divorce, if the divorce takes place before consummation of marriage and if the mahar is not fixed. Verse 240 deals with the provision of maintenance for widows, and it requires Muslim men to make a bequest for 1 year's maintenance and residence for the wife after their death. Now, in verse 240, this provision of providing maintenance for up to 2 years suggests, for up to 1 year suggests that such maintenance is not restricted only to the duration of the Iddah period, and a logical interpretation of fixing the time limit could be to ensure that a woman has support available until she finds another husband, or in case of pregnancy, she is provided maintenance till the birth of the child. Now, central to this debate on Mata is verse 241 of the Quran, which clearly states, for divorced women, maintenance should be provided on a reasonable scale. This is a duty on the righteous. Now, this verse does not set out any time frame for maintenance for the divorced women, nor does it lay down any specific limit as to the amount of the Mata. It states that reasonable maintenance should be given, and a review of these Quranic verses suggests that Mata is to be given with kindness and humility, and the Quranic legislation only lays down a minimum requirement, and nowhere in the Quran is there a prohibition on providing more than the minimum. So one can thus argue that Mata is also a safety net in cases where divorce takes place as a unilateral act of the husband, or in cases where it is the fault of the woman, where it is not the fault of the woman for which she is being divorced, and if she has no means to support herself after divorce. Verse 241 is followed by verse 242 in chapter 2, which states, thus doth God make clear his signs to you, in order that you may understand. Now, this verse is referring to the use of human mind and reasoning for interpreting the Quranic teachings and then arriving at a decision. In other words, it leaves sufficient scope to Muslims to legislate in this context. Similarly, in other places in the Quran, you will find references in which the Quran has held that there is a need for continuous study of the Quran, and which again is in conformity with the dynamic, progressive and universal character of Sharia as opposed to being immutable and unchangeable. Sharia is grounded in the authority of both revelation and reason, and it includes application, interpretation and enforcement of law by competent authorities. Now, based on these verses, one can argue for interpreting the verses on maintenance in a wider context, considering the principles of justice, fairness and well-being of those who are destitute and in impecunious circumstances. Now, despite these clear Quranic verses, the classical view is that there is no such obligation on the part of the husband to provide maintenance to the wife after the expiry of the iddah period, as the contract of marriage comes to an end. The classical view is that a divorced woman under Islamic law is supposed to return to her family and be maintained by her father, brother or whosoever is her legal guardian. Some scholars have gone to the extent of propagating the view that a man should pay maintenance only until the iddah, and that it would be a sin or haram for women to claim maintenance from their former husbands after the expiry of the iddah, as by then they would be strangers to each other. Now, this classical interpretation of Sharia law is based on patriarchal norms, and it reflects male domination and interests. These norms not only fail to provide protection to women, but they lead to social injustice and gender inequality and discrimination. The classical view has failed to foresee the situation where many women live by themselves and they do not have a legal guardian. Such views also raise doubt insofar as they contradict other provisions of the Quran, which insist upon providing protection to the vulnerable groups of society and treating women and children with kindness and compassion. The views of 4 Sunni schools of thought also differ on the question of payment of mata. The Hanafi and Hanbali scholars have adopted a more strict position on mata, recognizing the payment of mata as mandatory only in 2 situations. Firstly, where a woman is married without the fixation of dower and divorced before the consummation of marriage, and secondly, when a divorced woman whose mahar has been fixed but she was divorced before the marriage was consummated. So basically, Hanafi scholars have formulated these rules about mata on the basis of Quranic verse 240, but not considering Quranic verse 241. As compared to Hanafi scholars, Shafis and Malikis seem to be more balanced and liberal in their views, considering that any divorced woman who is not responsible for her divorce is entitled to post-divorce maintenance. Shafis provide a list of those who could be eligible for post-divorce maintenance, and that list includes even women who have been physically or mentally tortured or have faced desertion on part of the husband, or even those who have been divorced by ilah or by zihar. Malikis consider post-divorce maintenance as mandatory and not just recommendable. Now, in my study, apart from looking at the views of the 4 Sunni schools of thought and the classical view on Islamic law, I've also examined and I draw inspiration from the works of contemporary Muslim scholars such as Laila Ahmad, Shaheen Sardar Ali, Asma Barlas and Amina Wudud, who viewed the Quranic verses through the lens of gender equality. And in adopting the position that the Quran manifests gender equity, Ahmad, Barlas and Wudud emphasize the need to read the Quran through a hermeneutical lens as distinct from that traditionally employed by the interpreters of the Quran, while Ali using the method of categorization of rights to understand the egalitarian message of Islam. Ali argues that to achieve equality and non-discrimination, a strict implementation of the protective corrective category is an imperative prerequisite, and only then you could achieve substantive equality as opposed to formal equality. Now, drawing upon the Quranic verses that I've mentioned earlier and views of the various scholars, in my paper I argue that the Quran provides for the protection of women both socially and economically. Awarding mata comes under the protective category, and this can be given in light of the wider principles or the basic spirit of Islamic law. And to achieve this end, mashaqqa, hardship, darura, and takhayyur can be used under the umbrella principle of ijtihad, and the use of these juristic techniques would allow us to reassess and reinterpret the concept of mata in Islamic legal tradition. As the Quran says, we explain the signs in detail for those who reflect. Now, these juristic techniques have been formulated on the basis of cardinal principles of pure justice and genuine goodness. The Quran has at various places referred to giving latitude and relief on occasions when strict application of law can cause hardship. This principle of mashaqqa has been applied in cases of loans, hatta, and interdict, strictly providing maintenance during the iddah and not after the expiry of the iddah by the husband to the wife may cause hardship and difficulties. So negating claims of Islamic, and it will also amount to negating claims of Islamic principles of justice and goodness. It is therefore suggested that by applying such techniques, provisions for post-divorce maintenance could be made to financially support divorced wives. Similarly, the weak financial position of the ex-wife may form the basis for applying the juristic technique of darura or necessity, as in majority of the cases, women are financially dependent on men and they do not have their own earnings or means to support themselves. On the basis of this economic necessity of the divorced wife, compensation or post-divorce maintenance can be awarded to her. Moreover, takhayyur or eclecticism is the most dynamic technique in Islamic legal tradition that can be applied to address the issues which are not directly covered by the primary sources of law. We have already seen that takhayyur is a technique that has been used to develop family law in different Muslim countries, and the Quranic guidance on providing muta on a reasonable scale and the views of various schools of thought and Islamic scholars could form the basis of using this technique. Now, by using these juristic techniques and by following the Maliki and Shafi interpretation, post-divorce maintenance has already been included within the family law of countries like Egypt, Malaysia, Morocco, and Brunei. However, the situation is more complicated when it comes to India, Pakistan, and Bangladesh, where majority of the Muslims are followers of the Hanafi school of law. Now, in India, the controversy over awarding post-divorce maintenance to Muslim women began after the Supreme Court's judgment in the much celebrated case of Shabano versus Muhammad Ahmed Khan. Now, although it was not the first time that the court had to deal with the issue of post-divorce maintenance for Muslim women, as in its two earlier decisions, Fazlun Bai and Bai Tahira, the court had already concluded that Muslim women were also entitled to maintenance under section 125 to 128 of the Criminal Procedure Code 1973. In Shabano case, the five judges bench of the Supreme Court discussed the provisions of the Quran and views of the Islamic scholars in detail and concluded that a divorced Muslim woman has the right to maintenance even after the iddah is over, and that there is no conflict between the classical Hanafi requirement of maintaining divorced wives during iddah period and obligation of maintaining former wife who is unable to support herself as long as she remains a divorcee. Now, it is interesting to note that the court did not restrict itself to a simple legal response by referring to the constitutional and legislative provisions. Rather, in this case, it took upon itself to interpret the Quranic verses by reviewing a range of Islamic sources of law. and in doing so, it drew on the egalitarian ethics of Islam to ensure that Muslim women are protected from falling into destitution. The court concluded that there was no conflict between Muslim personal law and Section 125 of the CRPC, as the duty to make provision for a divorced woman under Islamic law fulfilled the purpose of Section 125 of the CRPC, that is, to prevent vagrancy and destitution. Now, this judgment triggered an intense debate in India, and it received strong criticism from the conservative elements within the Muslim community, who felt that it constituted an undue interference in Islamic personal status laws. Now, Muslims in India staged a countrywide agitation rejecting the verdict of the Supreme Court, and they demanded that Parliament should pass legislation to reverse the Supreme Court's judgment. Now, the government succumbed to the pressure of the conservative religious groups, and this led to the passage of Muslim Women Protection of Rights on Divorce Act 1986 by the Parliament to undo the effect of Shah Bano judgment. Ironically, the government did not take into account the views of many individual Muslims and other organizations who spoke in defense of the Shah Bano judgment. And by enacting this law, the Parliament accepted the male-inflicted interpretation of the Quranic edict, and it absolved the former husband from all responsibility of maintaining their former wives. Now, this legislative enactment was a clear proof that the government had bowed down before the conservative and patriarchal forces within the Muslim community, thereby violating the principles of justice and equality for women. The interests of women in this dual legal structure were particularly subject to exploitation by alliance between the religious and political forces. The response of All India Muslim Personal Law Board and the Shariat boards to the Shah Bano judgment and enactment of the Muslim Women's Protection Act by the government highlight the extent to which gender equality is compromised by yielding to dominant forces within a particular religion or cultural identity. This act received severe criticism from various quarters, and scholars argued that 1986 Act is violative of the Indian Constitution, and it is discriminatory and unjust to Indian Muslim women. Various high courts in India also refused to apply the provisions of the Act, and in their judgments, they have nullified the effect of the 1986 Act compared to the 1973 Code of Criminal Procedure. A number of writ petitions were also filed challenging the constitutional validity of this Act, and it was after more than a decade that the Supreme Court of India finally decided to consider this matter in Danial Latifi versus Union of India case. Now, the advocates for the petitioner in this case argued that the 1986 Act was un-Islamic, unconstitutional, inhuman, and it has the potential to suffocate Muslim women. The Solicitor General, on the other hand, supported the Act by stating that personal law was a legitimate basis for discrimination and that it did not offend Article 14 of the Constitution. The All India Muslim Personal Board, as an intervener, also tried to defend the Act by stating that Section 4 of the 1986 Act was good enough to take care of avoiding vagrancy of a divorced woman, and that she should not depend on her husband. Now, after hearing arguments from both sides, the Honorable Bench upheld the validity of the Act, stating that its provisions do not offend Article 14, 15 and 21 of the Indian Constitution, and the court further held that in Section 3(1)(a), the wording of the section imposes two duties on the husband. First, to make a reasonable and fair provision for the divorced woman, and secondly, to provide maintenance to her. The reasonable and fair provision include provision for the future of the divorced wife, including maintenance, and it does not confine itself to the iddah period only. The court further held that the Parliament had no intention, nor had it provided that reasonable and fair provision was only limited for iddah and not beyond it. Now, in court's view, the duty to secure social justice was universally recognized by all religions, and vagrancy and destitution were societal problems that need to be resolved within a basic human rights framework. Now, by assessing the provisions of the 1986 Act vis-a-vis the constitutional mandates, the Supreme Court of India has finally provided a definitive interpretation to the vague clauses of the 1986 Act, and it has created more room for providing post-divorce maintenance to wives on the basis of fair and reasonable provision. By applying a multifaceted interpretative strategy, the judiciary in India has addressed some of the gender inequalities in Muslim personal law within the overall framework of legal pluralism. The use of religion, statutory, constitutional and human rights law framework in Shabano and Danial Latifi cases has resulted in giving the judges the discretion to put their own construction to the existing principles and to promote gender equality. While a uniform civil code remains elusive, such a strategy would ultimately help in achieving gender justice and equality for Muslim women in India. Now, in the context of Pakistan, Pakistan inherited the Criminal Procedure Code from the British India, and matters relating to wives' maintenance were supposed to be dealt with under Section 488 of the CRPC by the courts in Pakistan until the passage of the Muslim Family Laws Ordinance 1961. However, between the years 1947 to 1961, only 2 cases on post-divorce maintenance were reported to the courts, and the courts refused to allow post-divorce maintenance on the basis of Section 488 of the CRPC, and it stuck to the traditional view that that maintenance can only be awarded during the period of iddah. The issue of mata was later on taken up by the 1956 Commission on Marriage and Family Laws, and in its report it made recommendations to consider the plight of women who are arbitrarily divorced. The Commission recommended that in such cases matrimonial courts should have the jurisdiction to order husband to pay maintenance to the divorced wife for the rest of her life or until she remarries. However, the recommendation of the Commission on post-divorce maintenance was not included in the Muslim Family Law Ordinance 1961. This matter was later on taken up by the Pakistan Law and Justice Commission in 1998. Now, this commission noted that the provisions of mata are in force in various other Muslim countries where it is paid in addition to the payment of mahar and maintenance during the iddah period. The members of the commission also expressed the view that the Quranic revelation are neither time nor space limited, but universal and eternal, and therefore there is always a need for fresh ijtihad on current and emergent issues in keeping with the prevailing situations of the society. Now, the matter was again discussed in 2009 after the discussions and deliberations in 1988. No step was taken to incorporate mata in the Muslim Family Laws Ordinance. So the matter was taken up again in 2009 by the Pakistan Law and Justice Commission, and the Attorney General in the meeting observed that Pakistan is being criticized all over the world for violation of human rights, and supported the proposal by contending that it will raise the image of the country in the world community. It was also proposed in this meeting that a column in a marriage contract should be included in which an amount may be fixed as mata at the time of the marriage contract. The Commission also proposed that there should not be any time limit or period specified for mata, and an interim mata can also be awarded during just like an interim maintenance is provided by the law. So in light of these various suggestions which have been made from time to time by the members of the Commission, finally a draft bill, Muslim Family Law Amendment Act 2009, has been submitted, which includes a new clause on post-divorce maintenance. However, these proposals are still in their initial stages, and the government or the parliament has so far not taken any step to incorporate this suggestion or this recommendation made by the Pakistan Law and Justice Commission. Now, in the case of Pakistan, it is also interesting to note when the Commission sought the opinion of the Council of Islamic Ideology on this issue. And the Council of Islamic Ideology laid the responsibility of awarding post-divorce maintenance on the legal guardian of the wife, and in the absence of a legal guardian, upon the state. The Council of Islamic Ideology refused to accept the payment of mata after the expiry of iddah, and it absolved the husband from any such obligation towards the former wife. Instead, this Council of Islamic Ideology proposed a draft legislative bill for providing nafaqah or support to the destitute family members, which included mentally and physically retarded family members, but it did not mention divorced women, and it also did not include the husband's responsibility to pay nafaqah during marriage. Okay, I'm nearly there. Now, in Bangladesh, the issue of post-divorce maintenance was raised in Hafizur Rahman versus Shamsun Nahar Begum case, and the division bench of the High Court via suo motu considered the legal query of whether the divorced wife could claim maintenance beyond the iddah period. And after establishing their jurisdiction to interpret the Quran in light of the various Quranic verses, the judges presiding over the case stated that maintenance is applicable not only during the iddah but also for the rest of her life unless she marries again. Now, the judges based this interpretation on the Quranic translation by Yusuf Ali of verse 241. Now, this decision created some hope that Muslim law in South Asia was capable of self-expiatory reforms by reference to the Quran itself, rather than the less positive juristic opinions on the matter. It was an example of judicial activism and was considered as an enlightened and courageous judgment. However, critics of this decision blamed those who supported it as anti-Islamic and propagating Western agendas, and a judgment that was delivered in a rush without seeking any legal advice of the religious scholars. So as a result, the decision of the High Court was challenged in the Appellate Division of the Supreme Court of Bangladesh, which overruled the High Court's decision. Now, the Appellate Division held that mata was never understood as regular maintenance. Rather, it was deemed to be a parting gift to a divorced woman and a gesture to comfort for the trauma she has suffered because of the divorce. The judges in their decision relied on the commentaries of Hanafi law, particularly the Hidayah and the Fatwa Alamgiri, interpreted in light of the British common law traditions. The learned judges have applied a narrow interpretation to the Quranic verse by suggesting that there is no room for change, and the Islamic law is eternal and immutable. Although the court did accept that mata is a recompense or a consolatory gift to the wife, but it appears that the judges in the Appellate Division just missed the historic opportunity to take judicial action on post-divorce maintenance like other countries in the Muslim world have done through legislation. Such an appropriation of Islamic legal tradition has consequences for the Muslim women who are left at the disposal of their families to look after them after divorce, and who in many cases are either unable or unwilling to provide support to them. In the end, I just have to make a few concluding observations. And I would say that judicial activism can bring social change, and it can provide social justice to the vulnerable sections of the society. The three countries, India, Pakistan and Bangladesh, share the same constitutional and legislative history and socio-cultural backgrounds, and the judiciary in these 3 countries can share and they can learn from each other's experiences. Shahbano and Danial Latifi cases stress the need for reform and gender justice. In India, Pakistan and Bangladesh have also signed and ratified international conventions, and they have also incorporated the principle of equality and non-discrimination in their constitutional frameworks, and are therefore under an obligation from Islamic perspective as well as under constitutional and international human rights framework to enforce the principle of mata through legislation by the parliament or by judicial action by the courts. And finally, the principle of mata needs to be interpreted by adopting an inclusive approach, which would include looking at the wider Islamic principles of justice, fairness, compassion, and equity vis-a-vis the international human rights norms of equality and justice. Such an approach will help in distinguishing between the actual teachings of the Quran and customary practices and patriarchal norms that are adopted in the name of religion. It would also help in creating deeper linkages and an ongoing dialogue between the Islamic legal tradition and the Western notion of human rights. As in the words of Sirajuddin, a comprehensive, well-informed and reasoned exposition of judicial activism and creativity in the interpretation and application of Muslim family law in South Asia is necessary and important, both in its own right as a social study and as a means of understanding and addressing the problems arising out of confrontation between traditional and modern values. Thank you so much.